Good morning and welcome to the Labor and Employment webinar on behalf of Aird & Burles LLP. Our topic today is Top Labor and Employment Trends of 2019. A look back, a look forward. It was a busy year in labor and employment law in 2019, and we want to talk about some of the major trends and some of the major cases which came up, which impacted employers across the country, both provincially and federally. I am joined here today by my colleagues, Michael Horvat, Megan Cowan, and Daria Paragodova. They are going to take us through our review of 2019, and we're also going to try to keep some time for questions. We do have some questions, but send them in. We usually do a review afterwards and send out a newsletter answering some of those questions. So let's talk about what we're going to do today. This is, we have a lot of people on. We have 3,000 registrants today, which is great. Thank you very much for your continued patronage. We really do appreciate that. The first topic we're going to deal with is human rights accommodation from mental health to family status. We chose this topic because it was consistently the topic that came across our desk with clients. Mental health and family status accommodation were probably the most sought after pieces of advice from us from a labor and employment perspective, and that's why we wanted to look at them. We'll look at enforceability of termination clauses in employment agreements, craziness, more craziness, independent contractors and fixed term contracts. There is a big case that we want to discuss. We'll give you a wrongful and constructive dismissal update, and then we'll tell you what's coming in 2020, give you a brief overview of what we think might be on the horizon for that period of time. So let's get right into this. Human rights and accommodation. We're going to start with mental health. So mental health on the 10th anniversary of Bell's Let's Talk Day. It actually is it's the very day that they started this 10 years ago. And so we thought it was a good idea to kind of give you an overview of this. It is and it remains the leading cause of disability in Canada. It is broadly defined under legislation. If you look at some of the stats, they're quite staggering and not even reflective of up-to-date numbers, which we think would be a lot higher given the prominence of mental health issues in workplaces, including Aird & Burles here, where we've put programs in place to address mental health issues. They expect that 70% of the disability costs may be attributed to mental illness. It's a very, very high number. I think most employers are now getting used to that, but it is still difficult given in many cases it's what we call an invisible disability until you either find out about it or are told about it. We don't have an absolute categoric list of what's a mental illness disability in Canada, and the symptoms can range. But where it imposes limitations on ability of an individual to participate at work, to perform the regular duties of their job with or without accommodation, that's when we get into it. All right, want to make sure that that we're clear that personal characteristics and normal ailments don't constitute mental disability pursuant to legislation or at law. We're quite strong about that, but it highlights the impact and the importance of ensuring that you have proper information to make that determination, proper medical. All right, we're not doctors. Everybody out there is really good HR professionals and we're pretty good lawyers, but we're not doctors. We got to leave that to the doctors to tell us exactly what the restrictions are. All right, so that's a really big part of this, is that in assessing this, we need to understand it, and to understand it, we need information. And employers are allowed to get information. Just got to be careful about what you ask for. When we look at the most common question that arises from mental health issues in the workplace, we see employers saying, look, this is the aberrant behavior. This is what happened. There was a fight, there was a dispute, there was misconduct, right? How do we address that? How do we know where it's related to mental illness? When can we discipline, right? And that's the distinction between culpable and non-culpable behavior, right? Employer must understand and take steps to find out whether the misconduct is related to culpable behavior, which is it's their fault, they did something which created the misconduct, or non-culpable, and which means that they have a medical issue which caused the misconduct. If that's the case, then we're in a position where we say, if it's non-medical, if it's culpable, it's disciplinary. If it's medical, which is non-culpable, right, we have to look at accommodation. Now, it doesn't mean that necessarily we're always in a position where we're saying we're not going to discipline right away. Sometimes even medical illnesses, if there's a failure to produce medical or information on a timely basis, can lead to culpable reactions. But the first thing we have to do is find out. And by the way, constructive knowledge can be deemed on an employer if they should have known that the individual was suffering from a mental illness. So I want to talk about that a little bit, the constructive knowledge part of it, because that really is the difficult part for employers. I spoke at the HRP last week. I got questions, and I was dealing with a different topic, but afterwards I got questions about mental health issues. We have an employee and this is happening. We think there's a mental health issue. What do we do? Well, here's the test. Did you have any knowledge of a problem? And that applies to things like addiction, right? We get questions all the time. We know the person has problems with alcohol or substance abuse. They're behaving badly. They're not showing up for work. We want to terminate or we want to do something right away. Well, you got to get in behind that because now you have knowledge, right? Was there any medical information on the personnel file? What do you say about what do you look at when you look at the company's or the individual statements, what their medical might be, what their conduct has been? In many cases, a mental health disability, somebody on medication, if they're off their meds, could result in misconduct, which in some way still might be related, but some way might also be disciplinary if they voluntarily choose to go off their meds. So sorting that out and looking at early indicators like increased absenteeism, the way their performance, their engagement, are they arguing with other employees? Is their behavior out of character? Have you gotten a change in their prognosis or treatment? Remember, we're not asking for a prognosis necessarily, but we are entitled to ask for, given this condition, once we know, or if we think we know, we want to know what the restrictions to your regular duties are. If you suspect a disability, all right, that's when you kick into gear. You look for medical information. And what do we want? We want the restrictions. If you suffer from this medical condition, just like any other, a bad back, what are the restrictions? Can you lift? Can you move? Can you climb stairs? All of the same things, but we want to know with respect to that mental disability. In many cases, when it comes to an addiction, for example, and the person is in a safety-sensitive position, we may want medical saying that are we obligated to bring them back to a safety-sensitive position if we can't be sure that if they are addicted to a substance, right? That becomes a live issue which you have to determine on a safety basis, right? But that's not every case. So let's not overwork that safety sensitivity thing. But I think that's information that we're entitled to get. So seek indications as to the permanence of the disability. What is the prospect for improvement? Can they come back to regular duties? Or is this a permanent disability? Is it short-term? If it's short-term, when will we know? When do we get an update in medical, right? Once we know, and once we confirm that there's a disability, you need a causal connection between the misconduct or the conduct which is at issue and the disability. If there is no causal connection, then it might be culpable. It might be blameworthy, all right? That's what we're looking for. Medical evidence is how we figure that out. It's important that we understand it. So that's a very quick overview of mental health in the workplace. I would say, from my practice perspective, possibly the biggest trend in accommodation and human rights in 2019, and something that we're seeing more and more of, and we expect in 2020. Michael, we're going to ask you to talk about cannabis 1 year later. Oh, sorry, Megan, sorry.
Thanks,
it's
Lauren.
Megan.
So, Michael, Megan gets confusing. So since the legalization of cannabis in late 2018, we noticed at the time there's sort of a lot of hand-wringing, a lot of worry, a lot of publication on this issue. And for the most part, it hasn't panned out to that degree. What we see most, though, is there's still some confusion and issue regarding how to treat employees. The biggest refrain we hear from an employee is, I have a right, this is a human right to use marijuana. And we want to dispel some of the myths around this and treat it very simply from an employer perspective. So basic principles. Recreational drug use does not mean that you can use cannabis in the workplace or come to work impaired. Just because it's legal doesn't mean, just like alcohol, you can't show up to work impaired. So remember what you can do under your policies. Employers can limit and restrict the recreational use of marijuana. They can prohibit impairment at work, and they can prohibit storage at work, all in the same ways that you already treat alcohol in the workplace. You can also require disclosure of impairment due to recreational use or medical use. So again, the starting point in all of this is treat it the same way as you treat any other substance like alcohol that could produce an impairment in the workplace. Where human rights are actually triggered are two areas. One, if the use of marijuana turns into an actual addiction, you would treat it as any other addiction and work through that process that way. Or two, if marijuana is prescribed by a doctor or medical practitioner to treat an underlying condition, you need to deal with and address the issue from that point of view. It's the same way as any kind of serious painkiller for a back issue, anything like that. That's what you have to think of it in that context. So those are the two areas that it does arise in the human rights area. So accommodating this. Remember, as Lorenzo always says, accommodation is a two-way street. This requires both the employer and the employee's participation. So if, on part one, if it's an addiction, you want to look at some things like discussing disclosure. This will be in your policies. The time away for treatment. So give the employee chance to seek help, take some time away on a leave. How do they return to work? How do you bring them back into the fold and ensure that there's no further issues going forward? On the second issue, medical reasons, again, this is just like any other prescription issue in the workplace, like a back pain example that I gave before. You want to understand the medical information. So what authorization do they have for use? They can't just say, yeah, my doctor told me I need it. It's the same as any other prescription medicine. So you want to understand the authorization and the reason for use, the duration of use, how often they need to use it, and the level of impairment that they may exhibit while in the workplace. And this brings us finally to the issue of safety considerations. In the workplace, this is going to be front and center. There's been lots of publication in the media on this issue. Health Canada's view is that using cannabis or any cannabinoid products can actually impair concentration, the ability to think and make decisions. Especially now with edibles being legalized, there's a lot of misinformation and confusion out there. Health Canada has quite clearly said, the use of cannabis in this format affects you differently, and there's a lot of factors to take into consideration there. But again, the effects on an individual, it affects their motor skills, results in cognitive impairment, can lead to increased anxiety and panic attacks. All of these things are huge considerations, especially if you have an employee in a safety sensitive position. So when can you say no? No, we know you have a doctor's note saying that you need to use this marijuana for whatever underlying reason. However, we can't have you in the workplace when you're under the influence because of the safety sensitive nature of your role. There's a list here of some things to consider. One, what are the safety requirements? Two, are the bona fide requirements of the position not being met? If they are required to take, medical marijuana for whatever purpose during such times that will impair their ability to work on the job, you need to understand that and have a clear sense from the doctor and from the employee of what's going on. Now, remember, accommodation, there's a high hurdle in terms of up to the point of undue hardness, but there really is no, free carte blanche to just ingest or take anything while on the job. This is a very sensitive area that has to be navigated with all the facts at hand.
So one final thing before we move to Dasha. With respect to edibles, you're not going to be able to see those coming into the workplace. Nobody's smuggling a 40-ouncer into their, in their jacket pocket. But you need to have those processes in place where your supervisors and your managers are trained to understand the signs of impairment. If somebody takes a little gummy while they're at work and they're impaired, we need to understand how to recognize that and how to deal with it. So your policies really do need to be robust when it comes to that. Dasha.
Thanks, Lorenzo. So we're going to move on to our next trend of 2019, and that is the growing scope of application of family status as a human resources issue. And first, just before we get into it, one of the important questions to ask is, why does this continue to be an increasing pressing issue, and why does this continue to grow in scope, and why do we see so many cases and situations arising out of this? And it will come as no surprise to anyone that it's largely because the number of seniors continues to rise as a result of the baby boomer generation growing. So there are some statistics on the slide there. I won't go through all of them because you'll be familiar. However, suffice it to say that the impact on employers is significant. And that's primarily because if you look at that fourth bullet point there, 43% of employees have to arrive to work late or early, or leave early, 15% have to change their weekly hours, and 10% have been known to pass up promotions because of caregiver obligations. So if you think about that in comparison to a workplace where everyone's on the same schedule and no one has to change their work routine, so to speak, that is significant. That's a significant amount of accommodation and consideration. We also know that you might have heard the term sandwich generation. This forms the largest part of the workforce, and these are individuals caught between the conflicting demands of caring for children and caring for seniors. So when you think about the demands on that specific workforce, naturally the accommodation issues for employers are quite significant and to be considered. And we do see that coming up in not only cases, but also just advice on how to best handle that regularly. And we did certainly in 2019. So moving on to actually family status discrimination. So a distinction that's important to make is that unlike marital status, family status has a specific definition under the Human Rights Code, and that is defined as the status of being in a parent or child relationship. So certainly marital status does provide protections under the code as well, but when we talk about family status discrimination, it is a specific definition. The way that, because childcare forms such a big part of that family status definition and the considerations under family status, it's important to just remind everybody the legal test for childcare because of its significant intersection with employment discrimination and family status discrimination cases. So we see there's a test that was first set out in a case called Canada Attorney General in Johnston, and there are 4 parts of that test: parental obligation, legal obligation, reasonable efforts, and real interference. Specifically, parental obligation means that the employee themselves must be the parent that's responsible for the child's care. The legal obligation is the employee's childcare obligation must engage their responsibilities to the child rather than just being merely a personal family choice, and I'll get into that more in a second. Reasonable efforts is that the employee must show that they've made reasonable efforts to balance childcare and workplace obligations. And again, I'll get into that more in a second, but it's that two-way street that we've mentioned a couple of times already. And the real interference part of the test is that the workplace must actually interfere with those obligations to childcare in a matter that's significant and not just trivial or occasional. So in a little bit more detail, and Michael is going to get into some specific cases in just a minute, but in terms of some overall overarching trends in the case law, what we continue to see is that courts are likely to say that an employee must demonstrate that they actually have made efforts to, quote unquote, self-accommodate, and that forms part of that childcare test. So they're not required to exhaust all possible options. So this isn't meant to be unreasonable. However, they do have to actually demonstrate that they've considered alternatives to their situation and that they've themselves considered certain accommodations or changes that can work as that two-way street with the employer. So for example, alternative daycare, other family help, other scheduling, perhaps a temporary leave of absence if the situation requires it. So more than anything, it's just important to say that courts are cognizant of that, and family status discrimination has not been taken to an effect that becomes terribly unreasonable on the employer. The employee does still have obligations, which are significant. The other trend that we're seeing in the case law is that the employee has to show that the negative impact, if they are alleging family status discrimination, they do have to show that the family need actually has resulted in a real disadvantage to the parent or child relationship. So it can't just simply be a preference. The example we have there, it's very different if you just want to attend your child's soccer game, which of course is understandable, but it's different if, you know, that soccer game forms part of a child's sport as therapy, or if perhaps there's another situation that actually requires a child to be somewhere rather than just a preference. And the last trend is that it's still process-based. So if an employee can demonstrate that the disadvantage and the alternatives have been tried, but they simply don't work, then the onus shifts to the employer to show that that the employee can't be accommodated without undue hardship. So there is a process that forms part of that test. And I'll say it again, it's that two-way street where both employee and employer have to work together. I'll pass it on to Michael now to speak about some specific cases.
Thank you, Tasha. So with respect to specific cases, I want to take you through two cases that happened later part of 2019. And they're really fundamentally common sense reasonableness cases. In one case, you've got an unreasonable employee, and in another situation, you've got an unreasonable employer. And the facts of these cases can identify how human resources professionals can attend this in their workplaces. So the first decision is Envirocon and Suen. This is a case that went all the way and referred to all the way to the Supreme Court. So this is how these cases can sometimes get out of hand. The employee here was on an assignment. The assignment required him to leave the province and work in Manitoba from BC. He was a recent father, and he indicated to his employer he couldn't go for the 8 to 10 weeks that they were asking him to go for. It did turn out, however, that his spouse was at home with the child during her maternity leave. And so the question was, could this individual even attest to the fact that he needed the family protection or parental protection under the BC Human Rights Act? Ultimately, the Court of Appeal in BC said no. He hadn't justified determining the fact that he was entitled to this benefit because there was another parent who could take care of the child. Fundamentally, I think that the key takeaway from this case is that it didn't show that the employee was being reasonable at all. There was no explanation as to why the additional care was needed. There was no indication that the remaining spouse on mat leave could not take care of the child on her own. Certainly the facts would have changed if she was also in a medical situation. None of that was brought to fore. And so simply refusing to take a direction from the employer with essentially no background or reasoning for it permitted the employer to take the drastic step of actually terminating this employee, essentially for not following direction. It's quite clear here that the implication also was that travel was a regular part of this person's job. Because if it hadn't been, we would have been talking about a constructive dismissal issue. So that one is always in the background. Anytime you've got a termination or, a decision to make a change in employment, always remember it's not just the human rights factor, but it's also just plain old employment contract matters, that what you cannot be asking an employee to do something dramatically different without notice. The next case is Simpson and Pranjan Group. This is a bit different because this is a case of the unreasonable employer. In this case, you had an employee who came forward, had a special needs child. This is an employee who gave notice to the employer that a change in her hours could not be accommodated at this point in time. She needed time. She was looking into daycare. And at the same point in time, she got ill. And that hampered her ability to now not only attend at work, but also find alternatives for childcare to meet the change in hours. Ultimately, the employer took the step of terminating. Again, I got to say, it wasn't one of these problematic terminations. It's not about the fact that she's changing or giving us a hard time. It's all these, productivity issues that have come up to our attention. But clearly the timing was problematic, and the Human Rights Tribunal saw through that and ultimately awarded the employee $30,000 in compensation for injury for dignity to her feelings, because they found out that she was the reasonable one. She was the one who had made efforts, and in fact, the employer took the opportunity to take a step forward. So really, it's about the parties, at first instance, being reasonable. And for employers to understand at the first step when they're introducing changes to an employee's time schedule, to take a step back and say, how are these going to affect our employees? Let's think about this. Let's have a process in place if we get a situation where employees cannot accommodate. And what is our process to review that accommodation? Lorenzo?
Great, thanks very much. And you're bang on. This is really a reasonableness standard. Here's the interesting thing about family status accommodation. Human resource professionals are in the same position as the employees that are asking for the accommodation in most cases. They're also members of the sandwich generation. Oftentimes, we all have elder care and child care responsibilities at the same time, so we're in the same kind of a box. What I do find a lot of the time is that creates almost a more harsher or a more inflexible opinion on the basis of human resources, because they're saying, look, I did it, you got to do it too. You got to get a helmet, you got to move forward. But that's not always the right response. It's an understandable response, but there's a couple things you have to remember. If you're going to discipline somebody right away, that's going to be looked on, by courts or tribunals as being problematic. All right, it's going to look like a reprisal if you do it too quickly without making inquiries. So if you're going to look at discipline, think of these things. Look at the employment contract, like in the case of the individual who's being asked to travel to Manitoba. Was that a condition of their employment? Is that part of their essential part of their job? If it is, that's going to change the calculus in determining whether or not the accommodation is necessary or practical. All right. Make sure that you've done an investigation and looked into the possible alternatives. Right. Give the employee some feedback. Give them an opportunity to change the response, and advise them of what the possible consequences are, and document, number one. And number two, if you see that something has changed and it's reasonable, don't be afraid to change your mind. There is nothing wrong with that, and it probably saves you a lot of money speaking with people like us. But what you really need to focus on is it's still an accommodation process. It's procedural and it's substantive. You have to look for the accommodation if it's necessary, and then you have to implement it. All right, so explore the options. In many cases, the problem is that the employee comes with nothing. They just say, accommodate me. I just had a child, accommodate me. That's not the end of the inquiry. The inquiry really does go to looking at alternatives. What have you tried? What is practical in the situation? Are there minor shift changes, for example, that you can do? All of these things, like reasonable scheduling accommodation, all fit the bill for an employer who is trying to prove that they're reasonable in the circumstances, right? And that's part of the employee's responsibility too. And I think that last point on this slide, tribunals and courts, they will dismiss an application if the employee doesn't play ball. They've already made that clear. We've seen that in Ontario for sure. So if the employee doesn't want to participate in the accommodation process, they do so at their peril. If you, as an employer, don't look at reasonable requests and look for a possible accommodation and ignore those, you do that at your peril. So addressing it in a meaningful, practical, and reasonable way can actually undermine a lot of the ills that come from this. And that can include higher rates of illness and absenteeism, early retirement, people self-selecting out of jobs, even though they're good employees because they have elder care or child care responsibilities or both. So let's look at each individual accommodation request individually, practically, reasonably, know where we can press for information, know where we have to be reasonable, know where we may have to change our mind. That's very, very, very important. There's a good accommodation tip. Print this, put it on your bulletin board. You're going to need this one, right? It's good to know all of these things. Hit the brakes, pump the brakes once in a while when you get these requests, calm down, and then look at them reasonably. All right, investigate alternatives. Consider whether or not there's something that you can do rather than something which you just simply don't want to do, and document every step of the process. Right, that's a lot of information. You can take that slide. Our next topic, enforceability of termination clauses in employment agreements. I got to tell you, we have looked at this up, down, sideways, backwards, every possible way. And a lot of the decisions from 2019 dealt with the enforceability of employment termination clauses in employment agreements. We get these questions all the time. So what do you mean? We missed a word? or we missed a sentence and now that person agreed with the contract, they had a chance to review it, they signed off on it, and they are still saying that it's unenforceable? The answer to that is yes. And every single plaintiff case now, even stuff that is enforceable, we're still getting innovative arguments on how to overturn them. Courts don't like enforcing employment standard termination clauses in employment agreements. They got to be clear. They got to be enforceable. All right. So we're going to go through a couple of those right now. Megan, can you start us off on that?
Thanks, Lorenzo. So the case I'm going to be talking about is a 2019 decision from last August of Ontario's Court of Appeal in Andros and Colliers. This case, unfortunately, amplifies the uncertainty around termination clauses. It deals with two issues. The first being the effect and application of a fail-safe provision in a termination clause, and two, whether a termination clause that's silent on statutory minimum amounts or entitlements can be characterized as an attempt to contract out of that same legislation. So in this case, it really follows on a 2018 decision of the Ontario Court of Appeal in Amber and IBM. In that case, there was a termination clause that had a sentence, a final sentence in it, a fail-safe provision that said, if the Employment Standards Act provides greater entitlements than the termination clause above, the employee will then be entitled to the Employment Standards Act. That's essentially a fail-safe provision. So you can set out whatever you want for the entitlement, whatever the parties agree to, and you have some saving language afterwards that says in the event that for any reason this provision is not enforceable, the employee will get their statutory minimums no matter what. That's a fail-safe provision, and the 2018 decision of the Court of Appeal allowed it and said, in that case, it was a saving provision that worked. So that's where we were at the state of the law in 2018. 2019 came along with this case in Andros, and you can see the fail-safe provision here on the slide. It sets out that it's a bit inverse in that it starts out first of all that the person will get the greater of the Ontario Employment Standards Act or the following amount. So that was the fail-safe provision at issue. And now it went to summary judgment motion. The employee was terminated, they sued, and at the summary judgment motion, the judge concluded that that clause was unenforceable. So going back, if 4A applied, they were not entitled to severance under the Employment Standards Act, so that wasn't enforceable. And if 4B applied, no benefits were provided for, so that also violated the Employment Standards Act. So in that case, the motions judge actually found that the whole clause was void and unenforceable. The so-called fail-safe provision didn't save it, and sided with the employee and awarded them additional pay. This went to appeal, to the Court of Appeal. And at appeal, the employer argued that the fail-safe provision should apply. It should be read up to be compliant. The court rejected this argument, and it was because of the use of or after the fail-safe provision. It suggested that actually it didn't apply to 4A or 4B. So it was really due to the construction of this termination clause that distinguished it from the previous 2018 case that the court had looked at and allowed the court to distinguish and to strike down the clause in this instance. So, unfortunate case here, they had some good language, but the way that it was constructed and the way that it was presented in the termination clause didn't work with the 4A and 4B structuring, and therefore the court struck it down. So this is a cautionary tale, a cautionary case for employers to consider when you look at your termination clauses. Michael's going to discuss another interesting case of Rossman now.
Thank you, Megan. So a couple of additional cases here to show you how, as Lorenzo points out, courts don't like this, and how individual judges are really, taking the ball here and puts a lot of these clauses at risk, because it is going to be also dependent upon the judge that you get if this matter is going all the way to trial. In Rossman, you had a situation in which the employee had a pretty straightforward termination clause saying that they'll be provided with benefits of written notice of 4 weeks. So they get pay and benefits for 4 weeks. The problem here was that it was dependent upon the timing of the termination. Clearly, if the employee had less than 4 years of service, this clause would be within their employment standards obligations. It would actually exceed their employment standards obligations by a week. So the employer sought to enforce it on the basis that, given the fact that they were terminated in the first 3 years of employment, they were onside the ESA and it was not a improper clause. The court, looking back to some prior decisions, said no, you cannot have a clause that has certainty to it when it depends on a variable, the variable being when does the termination occur, because the employer could not make any kind of claim that had the employee been employed for 5 years that the clause was not offside the ESA. Clearly at that point, even with notice obligations only, they would have gotten 5 weeks, let alone the severance obligation that was silent in the original contract. So the court says you got to make this work at any time, whether you've terminated them in the first 3 months, whether you terminate them in 2 years or 10 years or 20 years. So to add some complexity to these clauses, you've got to be forward-looking as well. The court is not going to be a situation where they're going to save a potential drafting error. Essentially, the court's position is don't look to us to save an unenforceable clause. The problem from a strategic and contractual perspective is what's unenforceable is up to the courts nowadays. And so as we see with Megan and Lorenzo, you get good language that then gets in front of the wrong judge. And now you're arguing in front of the judge who's going to decide that your clause is enforceable when they're saying it's not, and I'm not going to save it.
So it gives you a bit of a sense of where we're going. There's lots of history even prior to 2019. But the real issue now is I'm getting calls from plaintiff counsel where you've got otherwise enforceable provisions that just say employment standards or the greater of, and they will say, well, your language is pursuant to the Ontario Employment Standards Act. That can't be enforceable because we don't know exactly what that number is or anything like that. I'm saying, are you kidding me? That's what the courts have already said is applicable.
And this is not to put off having fixed notice provisions in your contracts. It's, in fact, if you can get to an agreement on divorce now, it's always the best case. Just have some flexibility. Maybe add a few months, a few weeks, tie it to years of service so there's some upside potential both for the employee and a limitation on cost for the employer ultimately if termination comes around. There's a lot of flexibility, a lot of creativity that can go in these clauses as opposed to simply trying to limit it to the ESA. You still have the opportunity to make these clauses work.
Yeah, agreed. Next major trend and topic we're going to discuss is independent contractors and fixed term contracts. What's the point? Now, these have been the topic of a lot of conversation legally and otherwise from a human resource perspective for sure. And I'll tell you, from our perspective, we get a lot of push from employers saying, just make them independent contractors, or why don't we just throw a fixed term contract in there? Well, we know that these areas have been litigated, and it's the old phrase, you know, if it looks like a duck and it walks like a duck and it talks like a duck, it's probably a duck. You can't call it a dog. And that's the way that the courts look at these things. So if we're looking, let's start first with fixed term contracts. I get all kinds of questions. Put them on a fixed term contract. Put them on a fixed term contract. Why not? Let it expire and we'll deal with it. We're going to look at the decision on that, some decisions on fixed term contracts, but they're dangerous. And they're dangerous because if you don't have a proper termination provision in there, it could be found that even if you terminate them early in the contract, the employee is entitled to payment to the end of that contract, even if you terminated them on day 3. And from my perspective, I try to explain to employers, I don't understand why you just don't give them a regular contract with a termination provision that's enforceable and let it go, right? I don't know why you need that endpoint. You can still terminate them at any period. So that's one of the things we want to look at. And Megan's going to talk a little bit about that. Oh, sorry, Dasha. Sorry, there you go.
I don't know if we have that same excuse with Dash and Megan sounding the same. Lorenzo's he's on the hook for this one. So Actually, when we were, the trend in case law that Lorenzo's referred to is absolutely accurate. But when you look back at the cases of 2019, there's one that stands apart from the rest, and that's specifically because of the huge damage award in this case. And it's the one that's most often been referred to now as signaling the risk factor in these types of contracts. So in this case, the facts were, it's colloquially referred to as the funeral home case. But in this case, Mr. McGinty was a third generation owner of a home. And in 2012, he agreed to sell his shares to a numbered company. And as is common in these types of share purchase agreements, he entered into a consulting agreement with the funeral home, thereby, staying involved to some extent, but no longer being a part owner or an owner. So by this consulting services agreement, the terms were that he would continue to be employed for the funeral home for exactly 10 years, hence being a fixed term contract. However, not long after the share purchase went through, some differences arose between him and the new owners. I recall something like his picture was taken off the wall, and I think a vehicle might have been taken away. Anyway, suffice it to say that there was some disagreement and some bad blood, so to speak. Mr. McGinty ended up going on medical leave due to workplace stress, and not long after, he brought a claim alleging that he had been constructively dismissed. He brought a claim for the breach of his consulting services agreement, as well as other things such as intentional infliction of mental suffering and discrimination. And this is where it gets fun as a cruel world, but it does get a little bit dicey here. So the judge actually held in this case that he was in fact constructively dismissed, and that could have had several impacts. But because the parties at the time that they entered into the agreement had not contemplated any kind of early termination at any point before the 10-year mark, the court actually held that he was entitled to receive all of the compensation and benefits he would have received had he actually served in that role for 10 years. And doing the math, and as a result, the 9 years that remained on his term amounted to approximately $1.3 million in damages to the funeral home. So on the one hand, this is a case about the danger of not contemplating early termination, even in a fixed term contract, but it's also a case about fixed term contracts in general. And just because you have a fixed term doesn't mean that other considerations aren't in play. So they do have to be carefully drafted. And we're moving on to the next topic. And now it is Megan.
There we go.
Thanks, Dasha. So we're going to be giving some case law summaries on wrongful dismissal updates. The first one that I'll be getting into discusses a 2019 Court of Appeal decision discussing the new cap or upper limit on the threshold of damages. And then Michael will be discussing a case that involved some bad faith conduct on the part of an employer. So in Daw and Equitable Life Insurance Company, this is a 2019 decision of Ontario Court of Appeal. The employee was 62 years old and had worked his entire life for the company. He'd been there since age 25 and worked 37 years, ultimately ending up in the role of senior vice president with a very, very large compensation package. The employer terminated the employee. There was a sort of a small level dispute about some expenses claimed, and the employee actually sort of instigated his own departure by requesting an exit strategy. Ultimately, the parties parted ways, and during the termination discussions actually offered 24 months to this gentleman. He thought he was entitled to more and brought an action for wrongful dismissal damages. And at trial, he provided evidence that he intended to keep working for another 3 years or until he was 65. And on that basis, the motions judge awarded him 30 months wrongful dismissal damages on the basis that there was no mandatory retirement at the company and that the individual had indicated an intent to work up until age 65, which would have worked out to the 30-month period. So this case went to appeal. Obviously, the employer appealed the 30-month award, and the Court of Appeal overturned the lower court decision. The court confirmed the approach that had previously been taken in Lowndes and Summit Ford sales, in which the court had held that only in exceptional circumstances should a notice period exceed 24 months. So this is a good case for that fact. 24 months is deemed to recognize and reward lengthy service of employees, and the court has now weighed in on this matter twice, saying that only in exceptional circumstances should a court go above the 24-month threshold. Now, this still begs the question, what is an exceptional circumstance? I mean, I think you can take from this case that a senior management position, an employee of 37 years was not deemed to be an exceptional circumstance. So that's good news for employers on that. As I referenced before, the employee actually sort of initiating his request for an exit strategy seemed to go to the court's mind as to something that would weigh against an exceptional circumstance. But what constitutes this is still rather fluid and is going to be determined on a case-by-case basis.
Thank you, Megan. Another case is Rushton and Kedco. This is a pure example of an employer going over the top with respect to being aggressive on a termination. The employee was terminated after 11 years of service for fraud. The employer provided no specifics, didn't even argue any evidence supporting the termination for fraud, and dropped its counterclaim of $1.7 million to $1. And it's a pure example of the courts slapping the hand of an employer who uses cause as a litigation tool or a leverage tool for negotiation. If you want nothing else from this case, take a look at the last bullet, which is the award of legal fees. This is the legal fees the company had to pay to the employee. $540,000, over $500,000. There was no benefit here of any litigation advantage. So really, when it comes down to cause, you either have a bona fide view that you can should pursue a cause case, or don't even bother, because the courts will penalize you. This doesn't mean that you don't allege cause where it's difficult to prove, or where you might not have all the facts, but you've got a strong suspicion, or you've got circumstantial evidence, or ultimately that the court may disagree with you with respect to terminating potentially a long service employee for maybe a bunch of minor acts. There's a difference between simply alleging cause in order to gain a litigation advantage, or not having cause, or having cause, but it doesn't meet the standards of the courts. One you'll get penalized for, as in Kedco. The other is just a failure to prove your case, and if you lose, you lose, but you're not going to get those kind of punitive damages awarded against you. So make that call at the time of termination. Another case, and this is a really important one with respect to trends that we're probably going to see a lot more of in the new year, is a Workplace Safety and Insurance Appeals Tribunal case. This is really important because it ties together our first topic of mental health to now workplace insurance. As you all know, when it comes to workplace safety insurance, workers' compensation insurance, that's an exclusive jurisdiction of WSIB. The exchange is that for employees, they get coverage for losses, but they have to give up the right to sue their company. In exchange, the company has to pay premiums. Right, in this case, you had a situation where the employee resigned from her position as a result of bullying and harassment. And shortly thereafter, she filed a claim for dismissal. The company took the position that the dismissal was not for cause or alleged constructive dismissal, but was a result of her failure to be able to perform her duties because of her medical situation that arose from the workplace. That is, the mental health issues. And WSIAT agreed. WSIAT said, you're right. These are situations in which this employee could otherwise work, but for this workplace injury, that workplace injury being mental stress arising from her performance or her duties. So the good news, constructive dismissal situation went away, no lawsuit. bad news for employers, and this is a potentially double-edged sword, is now this employee is going to be compensated under the Workplace Safety and Insurance Tribunal system, which oftentimes can be more costly than a constructive dismissal. So you got to know this on the front end. Is this a positive approach from the employer? But also, what happens when a worker brings forward a WSIA claim on mental stress? You got to be prepared for that now too.
That's an important decision. Thank you, Michael. Very quickly, off-duty conduct. We've got lots of this. The test still remains now, and arbitral law has really figured this out, particularly with the increased use of technology and social media, is that if the conduct of the employee while off-duty, Facebook posts, Instagram posts, discussions, video interviews, if it undermines and has a detrimental impact on the workplace or interferes with the employer's legitimate business interests, right, they've got a problem. There might be cause for discipline or termination. Labor arbitrators had said because of the social and public aspect of this now, they can create a hostile work environment. For example, employee posting about other employees or certain races or certain sexual orientation. We have examples of all of that. And it can damage the employment relationship, and there can be grounds for dismissal. In the Greater Sudbury Police case, it's a good example. There were 2 Facebook posts made by a police constable in which he questioned the salaries of civilian managers. The determination was that they were not protected under free speech under the Charter. Now, I did an interview the day after Don Cherry got fired from Sportsnet, and all of the questions were, isn't this constitutionally protected speech? No, it is not. Whether you think he is a patriot or a racist is a completely different issue. The issue is that he understood he was expressing an opinion. Employees have the right to express their opinion, subject to the employer taking the position that they no longer want them employed anymore, or that it detrimentally impacts their interests. So you can speak, but they can be the basis for a with or without cause termination. It's that simple. Off-duty conduct will be reviewed as to whether or not it undermines the employer's legitimate interests. If I come out and say something terrible in a post about this law firm, right, this law firm can say to me, I don't care if you were kidding, that actually went out to the general public, we got a problem. That's the way it works. Now, let's talk about briefly what's coming in 2020. Dasha.
Thanks, Lorenzo. So 2020 is going to be another big year in labor and employment. We're certainly monitoring a few decisions on appeal, both at the Court of Appeal and at the Supreme Court of Canada, that will have significant implications. And as those come down, we will certainly report on them. We have your questions here in front of us. There's quite a bit on medical cannabis and how that's to be accommodated, whether employers or rather employees have to actually disclose that they are using medical marijuana, et cetera. And we'll certainly be monitoring those changes as well as cannabis continues to settle in and that issue continues to become better understood in the workplace and outside. But the 2 changes we want to cover that are quite immediate are one that has already taken place. So right at the outset of the new year, the small claims court rules and the simplified procedure rules in Ontario have altered slightly, specifically with regards to the monetary caps. So in small claims jurisdiction, I'm sure you're all familiar that the previous cap was $25,000 in damages. That would be the maximum that a claim could be brought. And that has recently gone up to $35,000. So that's a long anticipated change, but very, very significant for employment law specifically. And I'll get into that in a second. In simplified procedure, the cap has increased from $100,000 to $200,000. So if your claim is within the $200,000 limit and what the damages that are being alleged, it now must be brought under simplified procedure unless the parties agree otherwise. So the cost awards have also been changed. The cost awards are now limited in simplified procedure to $50,000. So that's quite significant, and disbursements only $25,000. Oral examination time and trial duration have also been slightly altered. So all that's to say procedure has changed, but the caps are really what we're paying attention to. And the reason behind that is that the most employment-related claims seek damages within the scope of the new rules. I mean, it's quite rare to have, we've seen some cases, of course, where damages greatly exceed that. But for the most part, when we're dealing with, a notice period difference or disagreement of 2, 3, 4 months, they are within that either small claims limit and certainly within the simplified procedure limit. We know that a lot of employment claims settle precisely for that reason, because the value of going to trial is simply not there. By the time you get there, you will have spent a greater amount than you want to just to resolve the difference between the parties. However, now with the limits being increased, that may not only increase the number of claims being brought, but also how far parties are willing to go and how likely they are to bring those claims. It doesn't have nearly the same implications for commercial litigation, where usually the damages are well in excess of any of the limits we're talking about. So not only will it be important to seek legal counsel, but just understanding that we may see an increase in claims will be significant. Just by way of anecdote, I was recently at a settlement conference and I was on an employment issue, and I was really surprised at how robustly and intimately the judge that we were working with knew the nuances of the employment issues that we were dealing with. I mean, naturally, judges are knowledgeable people, but this was above and beyond. And I sort of politely complimented the judge on, I said, wow, you're really familiar with these issues. And he joked, well, we're basically going to become employment lawyers now. So that if that's not the signal of what's to come, then I don't know what it is. Very quickly, wanted to also cover a change on the federal side with the Canada Labour Code. In 2020, the federal government is set to introduce new administrative monetary penalties for employers that are code compliant. And these types of, the penalties will really range on not only the type of non-compliance, so whether it's a minor offense or major, but it'll also range depending on the type of employer. What is anticipated to come is that the violations will be classified on a scale from A to E, with E being the most serious offense. The amounts are still being discussed, as well as the time to pay, and that will to some extent depend on the size of employer, but it will be important to have proper education and counsel around the code as those amps come down.
Thank you very much, Dasha. So, on the issue of the small claims court, what we are going to see, and I think that's right, that they're going to become employment lawyers, but the small claims court judges that are available are not nearly as knowledgeable or, in my view, as good as the ones that you're going to get at Superior Court. So what we're going to start to see is decisions that might be all over the map in terms of employment law until things get settled. And I think that's problematic. I think this is a push by the courts to get more equity for employees as opposed to employers, and I think that's where we're going. Michael, you want to answer one of the questions? We've got a couple. We have some time to address these questions, so let's go.
We've got a couple of questions that came in and sort of trying to group this. A couple of the questions relate to what happens in circumstances of accommodation where the employee either asks for, applies for, or is questioned about their ability to perform certain hours on a shift or certain obligations on the shift, takes the position and then turns around and says, oh, can't do it now because of X, Y, family status, disability, or what have you. Is there still an obligation to accommodate? Short answer is yes, there's still an obligation to accommodate. You have to at least go through the process and determine whether accommodation is possible. Now, the fact that those were requirements of the position will aid you in determining whether or not they are a bona fide occupational requirement, but you still have to go through the process. We saw this some time ago, it's been some time now, when Sunday shopping first came into play. Applicants for retail positions would say, yes, I can work Sundays, no problem, get the job. And then a few weeks later say, in fact, no, I attend services on Sundays, so sorry, I can't come to work. That process still has to go through. You may be able to, in those circumstances, say, no, this was a bona fide occupational requirement, so we've reached the point of undue hardship. As you know, that's a high bar, but at least you have to understand that you have to go through the process. Another group of questions dealt with disclosure of medicinal marijuana. To what extent is that required now that we're in a legalized marijuana situation in Canada? The short answer is your policy can require the disclosure of use of medicinal marijuana, similar to any other opioid or prescription medicine that may have an impact. And really, that's the key. As we saw in a case that came out in 2018, where your policy is very clear that those disclosures have to be made, if it comes out that the employee failed to disclose, then you have options with respect to discipline and potentially termination, not because the person is suffering from an addiction or a disability, but because they failed tell you, and you have it clear in your policy.
And that might even apply if you're in a safety-sensitive position and they're using recreational marijuana, which may impair their ability to do the regular duties of the job in a safe manner, because they still have to disclose if that's an issue, right?
Yes, and when it comes to disclosure, there is an obligation for them to disclose. Now, but be clear, as we've said many times on these podcasts, what you can ask for is still limited. You're entitled to prognosis, limitations, restrictions, and any expectation of return to work and timing. However, if the employee fails to do that, then at the first instance, you're holding that person out of work without pay because they failed to meet their obligations under their obligations to aid and accommodation. And secondly, you may be down the road to terminating that employment potentially with cause for failure to follow direction, and potentially with frustration of contract because you can no longer accommodate them.
Talk to your lawyers before that, but that's a very good point, which is you have to go through a process. Another question, and then we're almost done. It has to do with the use of fixed-term contracts in certain situations. For example, where there's a maternity leave and somebody's being brought in for a 12-month period or for an 18-month period, or just for a temporary position that might be required. Now, it's always don't dispute the fact that you might use it in that situation, but you should always have a termination provision in there. Have a provision that says you're from X to Y, a 12-month period, but if we terminate earlier, here's what goes on. All right? You've already kind of given notice of the termination of the employment by the fixed-term contract itself, but if you're early, be aware of the fact that you still may have employment standards obligations. Set them out in the fixed-term contract, right? A lot of the time we see employers getting in trouble because they have just stacked fixed-term contracts, one or the other. That creates an issue.
The other thing to remember in a parental leave situation, you might hire someone for a year, but under the new changes, your employee that's away could suddenly say, you know, I've decided to take the full 18 months. And then you're in a position where you've hired someone for a year and you have to fill that gap, how you have to deal with it. So that's why you might want some flexibility, like what Lorenzo said.
All right. I think that's all we have time for today. Thank you very much again for participating with us, for joining us, and for your questions. We're going to address some of these in a future newsletter. We really do appreciate your support. So thank you, and we will see you at our next webinar. Have a good day.